Welcome to EUPrivacyForAll Session41 on GDPR, Article 3, Territorial Scope. Article 3 on the territorial scope lays down that the GDPR applies to the processing of personal data in the context of the activities of an establishment of a controller or a processor in the Union, regardless of whether the processing takes place in the Union or not. That is to say that the regulation applies to the processing of personal data of data subjects who are in the Union by a controller or processor not established in EU. In two cases. First, whenever the controller or processor has an offering of goods or services, irrespective of whether a payment of the data subject is required, to EU data subjects, or when there is a monitoring of their behaviour as far as such a behaviour takes place within the Union. So GDPR applies to the processing of personal data by a controller not established in the Union, but in a place where member state law applies by virtue of public international law. In Recital 22, it is stressed that regardless of whether the processing itself takes place within the Union, a processing of personal data in the context of the activities of an establishment of a controller or a processor entails the application of the GDPR, an establishment implying that the effective and real exercise of activity would be through a stable arrangement. The legal form of such arrangements is not a determining factor. In Recital 23, the controller or processor not established in the Union are reminded to be subject to the regulation where the processing activities are related to offering of goods or services to EU data subjects, irrespective of whether it would be connected to a payment. In order to determine whether such a controller or processor is offering goods or services to data subjects in EU, a set of criteria should be checked and a body of evidence. That is to say, the mere accessibility of the controller's, processor's or intermediary's website in EU, the existence of an email address in the EU or of other contact details, the use of a language generally used in EU, the currency, and others. But it is insufficient to ascertain such intention, so the set of factors should be assessed carefully, and it should be checked whether it makes apparent that the controller envisages the offering of goods or services to EU data subjects. In Recital 24, the controller or processor not established in the Union and monitoring the behaviour of EU citizens is supposed to be submitted to the GDPR. In order to determine whether a processing activity can be considered as monitoring the behaviour of EU data subjects, it should be ascertained whether natural persons are tracked on the Internet, including potential subsequent use of data processing techniques, which consists of profiling. In Recital 25, where a member state law applies by virtue of public international law, it is reminded that the controller only will have to apply the GDPR. In Recital 122, each supervisory authority is presented as being competent on the territory of its own member state to exercise the powers and to perform the tasks conferred by the GDPR. This should cover in particular the processing in the context of the activities of an establishment of the controller or processor in the territory of its own member state. Recital 80 underlines the fact that the controller or the processor targeting EU market regarding the offering of goods or services or monitoring the behaviour of EU citizens has the obligation to designate a representative, unless the processing is occasional, does not include processing on a large scale of special categories of data, or processing of personal data relating to criminal convictions and offences, and is unlikely to result in a risk for the rights and freedoms of EU natural persons. Article 4.16 on the definition of the main establishment clarifies that the controller main establishment is the one of its central administration, unless the decisions on the purposes and means of the processing of personal data would be taken in another establishment of the controller in the Union, and the latter establishment would have the power to have such decisions implemented. Regarding the processor, the main establishment would be the place of its central administration once again, or if the processor has no central administration in the Union, the establishment where the main processing activities in the context of the activities of the processor would take place. Currently, the directive lays down in Article 4 on national applicable law several key principles that are still laid down in GDPR, such as the fact that the context of the activities of an establishment is a core notion, the fact that being not established in a member state territory does not entail that the directive would not apply, and the fact that the controller, not being established once again in the community territory, but making use of equipment situated on the territory of a member state, shall be a reason to apply the directive. There is also the obligation to designate a representative for the data controller. What should accountable data controllers and processors get prepared for? First, knowing when the GDPR would apply. First case is in the frame of the context of the activities of one of their establishments in the Union, regardless of whether the processing takes place in EU or not. If the controller or processor is not established in EU, GDPR will apply whenever there is an offering of goods or services, irrespective of a payment, or when there is monitoring of EU citizens' behaviour. The last case targets the controller only, not being established in the Union, but in a place where the national law of a member state applies by virtue of public international law. The notion of establishment implies the effective and real exercise of activities through stable arrangements, and the legal form of such arrangements is not determining. Knowing whether it is apparent that the offer of goods and services or the monitoring of EU citizens targets one member state depend on factors such as the use of language or currency, or the existence of profiling. Finally, whenever falling into the scope of GDPR, controllers and processors should designate a representative in EU, unless the processing is unlikely to result in a risk for the rights and freedoms of EU citizens. The question we can have now is knowing more about this notion of context of the activities of one of their establishment that is used in GDPR and commented broadly by ECG lately.